I'd like to start by thanking you for joining us today and thanking Guardian for sponsorship of today's webinar. Guardian has been a longtime partner of ours and has certainly shared our vision in discussing this very important topic. I want to put out an extra special thank you and best wishes to all the companies in the New York area that have recently been affected by Sandy. If you're not familiar with the New York Enterprise Report, we are the media company that exclusively serves the small and mid-sized business market in the New York tri-state area and beyond through our monthly magazine, our digital magazine, NYReport.com, and business events, and of course webinars like these. You can visit NYReport.com for more information and to get a free subscription to our magazine. We can go to, there we go. And we have a packed agenda today, so I'm going to get right into it. Please take a moment to familiarize yourself with the control panel. We're going to try to cover a lot of ground in a very short period of time. On the control panel, you'll notice a question and answer feature. Please feel free to ask a question at any time during the webinar, as I'll be compiling them, and then we'll have a Q&A session with the speaker at the end of the webinar. We will also be recording this webinar, so if you miss anything, it'll be available. It typically takes about 48 hours, and we will send you an email when it is ready to let you know where you can find it. We're very excited to be producing this webinar today, as it is a very critical topic. Most of us have invested so much time and money in our businesses, and while we take our salaries and distributions out, there's of course another opportunity when exiting our business to monetize all the efforts we've taken over the years. Unfortunately, most business owners do not take the steps necessary to ensure that when it is time to exit, we can really reap the rewards of years of effort. Today, our speaker will give us an overview on how to make sure we can monetize our business at exit. Let me introduce our speaker now, Mark Brumbaugh, who is a consultant with the Business Resource Center for Advanced Markets at Guardian Life Insurance Company of America. Prior to joining Guardian in 2008, Mark held positions at Provident Mutual and Nationwide. He has extensive experience in working with insurance professionals to implement and understand the tax consequences associated with all manners of advanced planning techniques, including business continuation plans, executive benefit programs, charitable giving, and life insurance trusts. Mark is a member of the state bars of New Jersey and Pennsylvania, the American Bar Association, and the Society of Financial Service Professionals. Mark, welcome, and let's get started. I'm going to turn it right over to you.
Well, thank you very much, Robert, and thank you to all who have called in today. I really appreciate the time that you're willing to spend with me today. I can tell you that in close to 20 years in working with business owners, the number one concern that I see is a properly implemented and funded business succession plan. And that's what we're going to talk about today. Before we get into the details, I do have to make a note, as you see on the screen, that I'm not permitted to provide legal advice to you today, neither is the Guardian, and we will leave it at that. So here's our agenda. Now, we're going to take it as a given that a business succession plan is something that you're going to want to have, and we'll get into the details of why that is and what it can do for you. In light of that given, here's what we'll talk about. Who is it that's going to buy your business? We have an assumption that you've got an asset here that you can convert to cash, but only if somebody is willing to pay for it. Who is that going to be? Next point, how much are you going to be able to sell your business for? What exactly do you need to implement legally and logistically to make that happen? You know, what is a business succession plan? What are the elements of it? There's more than one way to structure a business succession plan, and we'll talk about how the different methods work and the consequences associated with it. And all power to you and great job if you've got a plan in place, but if there's not something within the plan that's going to allow the person buying your business or the entity that's buying your business to have the funds available to it, you haven't accomplished the entire planning. So you need to find out what it is that you can utilize to fund this plan, and we're going to talk about that as well.
Terrific. Before we continue, Mark, I want to get a show of hands, so to speak, and we're going to put up a poll right now. And the question is, have you taken steps to succession for creating a succession plan for your business? And if you can just quickly select yes or no. We're gonna take a look at that. And then, Mark, what we're going to do here is I'm going to turn it over to you as we collect the responses, and then after the next slide, we'll present the answers.
Okay. So I'm going to move on to the next slide.
Yeah.
And I'm going to share with you something that should be a little bit startling. I don't mean to start here on a downer, but it was a article that I thought was very, very compelling in the Wall Street Journal. And if you can get an August 30th copy from this year online or wherever you might get a copy, take a look at this article, "The Economy Stole My Retirement." It was really heartbreaking, and I'm going to read these couple quotes from the article. Just think about yourself in the position of this guy and what he might have been able to do to not be in this position today. Danny Sullivan dreams of gardening and spending time with his grandchildren, but that's just a fantasy. Retirement is out of his reach, at least for the foreseeable future. The 62-year-old founder of a small catering company spends his days helping stock bars with beer and ice, wooing potential new clients, and juggling 20 to 30 different events his family handles daily. I am so tired, I don't know that I'll ever be able to retire. Now, Danny's in that position for a couple of reasons. And if you take a look at that article, you'll see what he failed to do. Number one, he didn't have a succession plan in place that would allow him to transfer his business to somebody or some entity in exchange for the fair market value of it, number one. And number two, he had a totally incorrect perception of what the value of his business was. And when he did attempt to sell his business without a formal plan in place, essentially going out and trying to find a buyer, ultimately it was determined that his business was worth a small fraction of what he believed it was. So even if he could have sold it at that point in time, it still would not have set him for retirement. So he did a lot of things wrong, and unfortunately, I'm not sure what his future holds other than continuing to work. But you're on the call today. You don't want to be in that position. We're going to talk about some ways that you can not end up like Danny Sullivan.
So, Mark, we're going to now, sorry, Mark, we're going to show the results of the poll. And, Mark, you may not be able to see this since you're controlling the slide deck. 17% said they have taken steps for a succession plan. 83% said no. So there's a lot of people that hopefully at the end of this call, they're not going to end up like Danny.
Very good. Thank you, Robert. And for those 17%, good for you. I can tell you that in close to 20 years, I've yet to come across the perfect business succession plan. So for those who have implemented plans, I would suggest you talk to your CPA, your attorney, your advisor, and have them review it. Take a look at what you do have in place, and once we're finished with this presentation, you'll get an idea, in my opinion anyway, is what it should look like. And if it doesn't look like something like what we're talking about today, certainly there's room for improvement. So don't disconnect if you're one of those 17%.
Mark, we're now back to you.
Okay.
On the slide.
Can you hear me?
Yep, we can hear you, and we're back to you on the slide.
Oh, okay. I'm trying to move to the next slide, and I'm not having luck. Okay, next slide. Okay, there we go. So everybody on this call who is a business owner, which I believe is everybody, should have a business succession plan. What it looks like for each individual business is going to be different because each business is different. But just because you're a, quote, small business doesn't mean you have less of a need for a buy-sell plan, which is another term that we can use for business succession plan, than a large business. In fact, for smaller business, it's probably even more important. And why do we want this type of plan in place? Because as Robert mentioned, you've got an asset here that you can, if you plan for it properly, convert to cash in these events. When you retire, you could convert your business into cash. In the event that you die, for your family, so your family is not attempting to run the business when they have no experience running it, they can take the fair market value of the business in the form of cash and not have to worry about running around and finding the best buyer in a fire sale situation. And then also, in the event that you become disabled and you cannot continue on running the business as you have been accustomed to in the past. So these events, in addition to some others that I'm going to talk about, are situations where you want some plan in place that's going to allow you to step aside and take cash in exchange for your business interest. So if we're going to sell, who is it that we're going to sell to? If you're on the phone and you are in business with somebody else, whether it's a partner, and let's talk about the terminology here. If you're a partner in a partnership, we call your business partners. If you're in a corporation, of course, your partners are your co-shareholders, and if you're in an LLC, your partners are actually called members. In any event, you've got people that you are in business with who are also owners of the business, and they would be the logical choice to buy an interest in your business in the event that you die, become disabled, or want to retire. Now, what if you're a sole owner of the business, whether it's a corporation or a sole proprietorship? Who do you look to buy your business? I would suggest starting with a key employee, somebody in that business who has the wherewithal and the capability to take over from you. A lot of businesses that I've seen have family members, next generation, working in the business. They would be logical successors. And I'll take a little bit of a tangent here. For those of you who do have children in the business and you were anticipating leaving the business to your children in your will, that's always an option. But what you're doing there is essentially, number one, you're disinheriting your spouse. If you're not leaving all your assets to your spouse, you have left some business interest to your family, to your children, for example. You're disinheriting your spouse. And for federal estate tax purposes, if you leave assets to anyone other than your spouse, you may have a federal estate tax obligation due at your death, at the first death, where in most cases, if you plan properly, if you have the wealth that would generate a federal estate tax, you can delay it until the second death. So I would suggest if you are planning on passing your business to your children, rather than leaving it directly to them in the will, you might want to consider talking to your advisors about having your children buy you out in the event that you die or become disabled or retire, and have the cash from the sale go to your spouse. And that way you don't have an adverse estate tax result. And these passing business to family members are, each business is going to be different, but certainly something you want to talk to your advisors about the way to accomplish that. And let's say you don't have a family member in the business, you don't have a key employee you trust. I've worked recently on a case with a dentist, and he was in that position. What he did was, there was a dentist in the neighboring community, and they worked together on, in the event that one died, the other one buy out his practice and vice versa. So look to your competitors, other people in your industry. Now, big question, what is your business worth? And we talked about Danny Sullivan at the beginning. He had a misconception as to the value of his business. This study was done by an organization that is, I would suggest, just for your own curiosity, to take a look at all the issues involved with business valuation. You might want to take a look at this firm's website. The firm at the bottom, you can see their name is Spar Data, and their website is spardata.com. Fantastic information on business valuation and why it's important. But they did a study, and as you can see at the very top, business owners misjudge values of their business by close to 60%. So if you think your business is worth $5 million, it may actually be worth $8 million or $2 million. And there are really tough consequences for errors in both directions. Now, obviously, if you think it's worth a lot less than it really is, you've got a problem with the IRS, because you note that bullet there at the bottom, fixing the business value for federal estate tax purposes. If you plan and implement a buy-sell plan for a $2 million business, good for you, but if you die and the IRS values your business at $8 million or some higher figure, the problem is that they are going to want federal estate taxes on that number within 9 months, but your family has only received a fraction of that from the buyout. So be very careful that you have an accurate valuation done on your business. And there's law firms out there that do valuations, CPAs, a small percentage of them are accredited. I would suggest a professional valuation firm. You have an idea, I think, of what your business might be worth, but again, as this survey is saying, your idea is probably off by a significant amount. So get some professional help here. What exactly is a buy-sell agreement or a business continuation plan or a business succession plan, which all mean the same thing? I like to think of it as the business owner's will for the business. Specifically, it will cover when the business interest will be sold. The logical and most common selling triggering points are death and disability and retirement, but I'm also going to talk about a few other ones that are very important to include. What we're going to have within the agreement is a legal obligation for whoever the buying party is, whether it's your co-owners or the key person or family members, to purchase your business interest based upon the terms of the agreement. So they're going to be on the hook, and you have the peace of mind to know that if you retire, die, become disabled, this person has the obligation to come up with the funds. And that's the whole point here, is that we don't leave it to chance. We don't, in the small, closely held business market world, believe that we can go out on a moment's notice and find a buyer. It just doesn't work that way. Of course, there are exceptions, but for the most part, the small, closely held business is not a marketable asset. And if you do have to sell in a short period of time, you, your family, are going to be sorely disappointed in the amount of money that you're going to receive, as opposed to the fair market value that you have in your mind. So what you want, again, is somebody who is legally on the hook to pay for your business interest. So along the lines of the advantages of the buy-sell agreement, look at, again, I'm going to be touching on this a number of times, determines the value of deceased shareholders' interest for federal estate tax purposes, that middle bullet there. Very important that you have a buy-sell agreement in place with a formula in the agreement indicating how you came up with the value. That goes a long way in satisfying the IRS auditors. Estate tax audits are audited far more often than any other type of tax return. And if you've got a buy-sell agreement in place with a valuation from a professional valuation firm, or at least a formula in there that indicates how the business value was arrived at, there's no guarantees here, but you're less likely to have a problem with the IRS than you would without an agreement and without a indication of how you came up with the price for the business. All right, let's continue with the will theme, and this is a piece that, as you will find out at the end, you're going to be able to get a hard copy of from the New York Enterprise Report. And this is done in kind of a tongue-in-cheek kind of way, but think of this as the will of a business owner who didn't plan properly, as it says at the top. I'm just going to read a couple of these. I, John Smith, presently residing in the state of New York, part owner of Acme Widget Company, being of sound mind and body, do hereby declare the following. Number one, I hereby leave my interest in my company to my family to be divided among them as they see fit even though my spouse or children have no experience in operating and running a widget company. I have the utmost confidence that after my death, everyone will get along with each other, and that Jack Jones, my partner, who owns a portion of the company, will have no problems working with my spouse or children. Now, if you're chuckling to yourself, that's good. That the whole point of this was that it was meant to be.
I was chuckling out loud, Mark. I was
okay.
chuckling out loud.
Meant to be facetious. We know that that's not going to be the case, but by not implementing a plan, that's what you're setting yourself up for. So for the 83% who haven't taken the steps yet, this is what, something happens to you tomorrow and you are in business with someone else, you're relying upon your business partner and your family to get along. And turn that around, what if something happens to your business partner? Can you imagine running the business with the spouse of your business partner if they die tomorrow? So very important. Number 2 here, I hereby leave the responsibility of operating the company to my surviving partner, Jack, who I am sure will not mind working twice as hard and sharing all of the profits of the business with my family. So we often see situations where you do end up with the family of the deceased business owner going into partnership with a surviving owner, and it's so hard to make that work because the objectives of the parties, even if they like each other and get along, are going to be so different. If you're the surviving business owner, you're going to want to continue making the business profitable, investing back into the business. What do the surviving family members of a deceased business owner want? Money, right? And they want it all out of the business. They're not going to be so concerned with your issues with running the business day to day. So it's very, very problematic, as I probably don't have to say, but I am stressing this point that you don't want to end up in a situation where you're running the business with the family members of your partner. And go down to number 8 again. I hereby direct the IRS to ascertain the value of my interest for estate tax purposes. I am sure the IRS, as a division of the government, will consider the needs of my family when determining any estate tax attributed to my business holdings. It is scary when you see the results of IRS audits and tax court actions against estate tax returns. Even if the taxpayer wins, and there's some very good information that I'm sure you can find on Google that has some evidence of IRS tax court cases on business valuation. And often what happens is the tax court, if the IRS says the business is worth $20 million and the taxpayer says it's worth $5 million, often the tax court will come somewhere in the middle. Now, sometimes they agree entirely with the IRS. Seldom do they agree exactly with the business owner, but that happens too. But in all cases, what do you have? Legal fees and delay. And the average estate tax fight at the tax court for a business interest is over 7 years. So you want this agreement for all the reasons that we've talked about up to now, getting cash into your family in the event that you die, but also to provide something for the IRS to look at, to have less of a reason to audit you. If you've got a formula in there, if you've got a professional valuation, there's less of a chance that it will be problematic. Okay, so that's the last will and testament of the business owner who failed to plan properly. Take a look at that, and this is real-world stuff that we utilize to create this. Now we're going to move on to the types of buy-sell agreements, the types of succession plans. How do you actually implement the plan to sell your business? There's 2 main types: the entity purchase or the stock redemption plan. It's called an entity purchase if your business happens to be a partnership or an LLC. If your business is a corporation, we'll call it a stock redemption plan. And the other type is a cross-purchase plan. And we'll start out with the entity purchase agreement. This is the agreement between the shareholders of the business, the partners in the business, and the business itself. So the business agrees to buy you out in the event that you die, become disabled, retire, and some other events that we'll talk about later. Your business partner, if you have one, is not involved in the agreement with you. The agreement is between you and the business. And we're going to talk about the most important funding, most efficient funding devices to have the money available to see that the buy-sell agreement can be carried out. And one of them is going to be life insurance. Just be aware that if you implement a agreement where your corporation or your company owns life insurance on you or your business partners, you've got some rules under Internal Revenue Code 101J to be concerned about. Essentially, it's just making sure that there's a form completed prior to the policy being issued that the business informs you and your business partners that they're taking out life insurance on your life. It has to do with the tax-free nature of the death proceeds, and if you don't do that, your death benefit is going to be subject to income taxes. So these are things that your advisor should be aware of. I just wanted to point that out. Let's go into...
Mark, just to be clear, just a quick clarifying question. So with a stock redemption, as opposed to a stock sale, in a stock redemption, it's sort of like the company is buying, if there's two owners of a business, the company's actually buying the exiting partner out, as opposed to, I guess, from a legal standpoint, the other business owner is not buying the business owner out, but the results are the same. Is that fair?
Everything you said is accurate, with the exception of the results being the same. Yeah, there are some of the results that are going to be a little bit different. For the person that is, who has died or is retiring, the results should be the same for them. For the surviving owner, they're going to be a little bit different depending upon whether you do this stock redemption / entity purchase plan or the next version, the cross purchase plan. And we'll talk about what those results are as we move along.
Terrific. And just a reminder to everybody else, Mark, as you go to the next slide, if you do have questions, just put them in the question and answer box in your control panel, and we're already getting a few in.
Okay, so let's take a look at this real-world company named Example Inc. It's a C corporation, and it's worth $1 million. The shareholders, Al and Betty, have agreed on that price, which to them is fair and reasonable. Let's assume that the corporation, to fund this buy-sell agreement, has purchased life insurance on Al and Betty. For purposes of this agreement, and for this example, the business is worth $1 million, and the business owners are 50-50 owners. Of course, the value of the policy on each individual would be $500,000. Okay? Add one more piece of information to this example, and this will lead to one of the differences between this type of plan and the plan that we'll talk about next. The cost basis that each of the owners have in the business is $50,000. So Betty contributed $50,000 to the start of this business. Al did the same, and over the years it has now grown to $1 million. All right. Let's assume that Al passes away. Under this stock redemption plan, Example Inc., not Betty, Example Inc. must purchase Al's stock from his estate. The funding of that should be no problem, and the whole point of buying life insurance was that when Al died, the company received the $500,000 to be able to immediately transfer to Al's estate the value of his shares of the business. Okay? Now what happens with Betty? Let's go through the results. The $500,000 is paid to Al's estate. Does the estate pay any income tax for selling a $500,000 business back to the $500,000 business interest back to the business? No. And there's no capital gains. There should be no income tax because we're selling the business for the value that it is. And there was a stepped-up cost basis when Al died to his estate, meaning his estate now has a business with a basis of $500,000. They sell it back to the business for $500,000, and there's no income tax to Al's estate. That's the same for regardless of what type of business plan you have in place, whether it's a stock redemption or the next type.
So to be clear, Mark, so Betty now owns the business outright, and she hasn't had to go into her savings or into the cash of the business to buy out her partner. Al.
Absolutely, right. Okay. I mean, you've implemented this plan. I'm sure she has, through her agreement with Al, contributed to the cost of the funding for this. But at the time that Al died, the money came in from not Betty, but from the life insurance company to the corporation to buy out Al. And now, very importantly now, stepping aside briefly from the tax consequences, Al's family's out of the picture. And they're not dependent upon the continuation of the business. They don't have to participate. They've got the business interests in cash in their hands, and Betty doesn't have to worry about running the business with them. She owns the business 100%. Here's the one tax issue to take away from this type of structure where the corporation buys you out. Betty's cost basis remains at $50,000. So what is the result of that? Nothing in terms of what happened here at Al's death, but if she would want to later go sell the business to somebody else, she would have what? If the business is worth $1 million, she sold it for $1 million and her basis was $50,000, she would have a $950,000 taxable capital gain. So you'll see with the next type of plan that we're going to talk about, we can get a better result. And let's move on to that. That's the cross-purchase plan. And typically this is used if you've got 2 owners, or you can do it with 3 owners. We're going to talk about how it can get problematic if you've got multiple owners beyond 2. But this is where the agreement, the actual legal contract, is between the owners themselves as individuals. And they agree to buy out the other owner. So Al agrees to buy out Betty and vice versa. The company is not a party to the actual buyout. Let's use the same example, but at this time, the legal obligation, again, is in the hands of the individuals, and in order to fund that, they're going to want to implement funding that they own. So Al is going to own a life insurance policy on Betty's life, and Betty is going to own a life insurance policy on Al's life. The corporation is not involved in the ownership of the life insurance. Again, Al dies, stock comes into his estate, the cash comes into his estate from the buyout, and Betty receives the shares of the business. Let's talk now about the tax consequences of that. Income tax free, $500,000. Betty pays, or that should read Al's estate receives, Betty receives $500,000 income tax free from the death proceeds, and then uses that to buy out the Al's estate. And all of that should be income tax free. And when Al's estate sells the business to Betty, that should also be income tax free. Same advantages in terms from Al's estate's perspective. They're out of the picture. They have the $500,000 business interest, and they don't have to worry about running the business, obtaining profits from the business. They have the business value in their hands, and Betty doesn't have to worry about them interfering. But this result is a little bit better for Betty if she should want in the future to have the option to sell the business to some third party, because in buying as an individual the business interest, she receives a stepped-up basis from the shares that Al had. So his date of death share value was $500,000. She takes that as her basis plus her original $50,000 cost basis, and now her basis in the business is $550,000. So just by structuring it between them as individuals versus as a redemption where the company is buying the interest in the previous example, you have a potential to save yourself a lot of capital gains taxes.
So just to be clear, the importance of the additional basis is that if Betty sold the business the next day for $1 million, she'd only be paying tax on $450,000 instead of $950,000.
Absolutely. Absolutely.
Okay.
So those are the two types of buy-sell agreements. There are variations on them, but I would stick with those as you're talking with your advisors. And for most businesses with two shareholders, the cross-purchase is simpler, and you have a tax advantage of doing it that we just discussed. But every business is different, and you're going to want to talk to your advisors about which type of structure makes the most sense for you. Now let's move on to the types of events that you should have in your buy-sell agreement that would trigger the business interest to be sold. And most agreements that we see have death in there, and that's obvious why that should be, and retirement and disability are often in there. If you're disabled and you cannot work and you cannot contribute to the business, it's preferable for all parties involved, including the disabled person, to be able to sell the business interest and receive a fair market value from the other partner or the business in cash. Parties can go on their separate ways and the business doesn't fail due to the disability. Retirement, you want to have something in place, as we started out from the very beginning, saying you've got this asset here to convert to cash if you plan for it. We often hear of business owners who that is their retirement plan. They're going to sell their business. But unless you, I don't want to harp on this too much, but unless you actually put a plan in place that would force someone to actually pay you for the business interest, you're going to be searching for who is it that's going to buy your business at retirement. So retirement's in there. Now, here are some other things you want to think about. Voluntary, involuntary. If you want to leave the business for any reason, I would suggest that you would want the business to have a legal obligation to buy you out. And that you can do some interesting things, involuntary termination. If you forced out of the business for any reason, or your partner is, you want to build that in there as well. And you may even have a discount on the value that you're willing to pay to buy out your partner, for example, if they are terminated from the company involuntarily. Maybe that buyout price is a fraction of the actual fair market value. Bankruptcy and insolvency, very important. You can put it in your buy-sell agreement, a provision that if your business shares, or look at it from the perspective of your partner, if your partner has a bankruptcy issue, before your creditors have the ability to, before their creditors have the ability to get to the shares of the business, they're legally obligated to sell them to you. And the same type of thing with divorce or marital separation. We've got plenty of experience working with clients who absolutely have to keep up professional licenses, whether it's doctors, attorneys, engineers. If you lose the license, you can't be a contributor to the business. Do you, as a business owner, want to be in business with someone like that? Probably not, and you should think about putting something in your buy-sell agreement that's going to force a sale of that individual's interest back to you or back to the company. Conviction of a crime, I don't think we have to go too much into that, but again, it goes to do you want to be in business with this particular person? How do we fund it? If you have an agreement in place, if you've taken the time to sit down with your business partner, with your key employee who's going to buy you out, with your children who are going to buy you out, and you have the foresight to draft an agreement that says, in the event that I die or retire, you'll buy me out, that's a great step. But unless the money is there to actually fulfill that legal obligation, what the buy-sell agreement just becomes is a right to sue for the payment. If you've got funding in addition to the legal obligation, you've got that much more certainty that your family is going to receive the fair market value of the business, or you'll receive it when you retire. So look to some of these most common funding devices, and let's talk about how effective they are. Company surplus, creating a sinking fund, essentially an investment that you contribute to on a regular basis to create a nice pot of money for purposes of funding the buyout. An installment payment that allows the seller to purchase the buyer to purchase the business over a period of time. Go to a bank and say, hold out your hand and say, I'd like to borrow some money to buy this business interest. And then for those risks that we can transfer to an insurance company, namely life and death and disability, let's look at insurance as one option of funding the agreement. So surplus, let's talk about a little bit more detail. And it's just so uncertain, and that's the point. And will you, when your business partner dies or retires, have the money in the corporation to fulfill the obligation, or is the act of death and retirement disability going to completely bankrupt the business because the funds aren't there to be able to make the payments that are obligated under the agreement? And again, if you have an event tomorrow, such as death, you haven't had a lot of time to think this through. The surplus isn't there, and we don't know what's going to happen tomorrow. Are the funds there tomorrow? Sinking fund, we've got, again, at that last bullet point, no guarantee that you've accumulated the sufficient amount for the buyout within the period of time that it's necessary. And you have to have some kind of willpower to be able to, on a regular basis, send that money to the mutual fund or wherever it is that you're going to invest that money. And, of course, in most cases, you're probably going to have some income tax on the investment that you've chosen to use to fund this. I think it's very, very I don't know the right word to use, but it's problematic to think that you could rely on the ability to go to a bank to borrow for a buyout obligation. And think about what's happened with the business. Let's say your business partner passed away and you've got an agreement in your hand that says you have to buy her out for $1 million. Well, how's the bank going to look at this asset now that one of the main reasons it was successful is no longer in the business? They died. It's very, very unlikely that you'll be able to rely upon borrowing, and even if you would, it can get a loan. What's the interest expense? And again, there's no guarantee here. Now, installment should be a part of most agreements because there are some events that you just can't transfer the risk. Retirement, separation from service for any reason. Typically what the agreement will say is that if it's Robert and I in business together and I retire, Robert will buy me out over a period of 10 years. That allows the business to continue on. It won't be financially unable to make a huge lump sum payment of my, for example, $1 million business interest. It'll allow me to spread the tax over a number of years if we fund it properly with an installment sale. So this should be part of a buy-sell agreement for the lifetime buyout options that you can't transfer to an insurance company. And also, if you don't have enough insurance in place, it should be your fallback plan. So you're not obligating the business owner who is surviving to come up with the buyout amount in one lump sum or nothing. And I would highly suggest you look into this. Transfer to an insurance company those risks that they can insure at a far lower cost than you could. You don't want to self-insure your life. You don't want to self-insure your disability. You can ascertain the cost. You can take a look at every age and at every amount how much this is going to cost, and we know that it's going to be available for life insurance in the event that you die tomorrow. If you meet the definition of disability under the plan, it's going to be available. And the nice thing with life insurance that has some cash value in it, and go back to our Al and Betty example, if instead of Al dying, he retired, if Betty had a cash value life insurance policy on him and a legal obligation to buy him out over a period of 10 years, because that's what the agreement said, she's got this additional source that she wouldn't have otherwise had. She had to buy the life insurance to fund his death buyout contingency. But if we funded that with a cash value life insurance product, she would also have a pool of money from the cash value to draw on. And if you treat your life insurance properly and do everything that you need to do from an implementation standpoint, the advantage is that the death benefit is tax-free, and the money that you get out of the life insurance contract up to the amount that you put into it, and then a properly structured loan after that is all tax-free. You can't get that with any other type of investment. And it's pennies on the dollar of actually self-insuring. So that's the funding options for your agreement. The legal agreement and the funding need to be there for your agreement to be sound. I would suggest you take this slide. I'm not going to go through it in detail, but it takes the two types of buy-sell structures and puts them side by side, talks about the advantages and disadvantages of both. Your advisors who are going to help you through this process should be aware of what these advantages and disadvantages are and which plan makes the most sense for you. I would also suggest, as you, again, will get a copy of this, that you sit down with this checklist, to go through it, and find out how far along you've gone in the process, if you've even started to think about it, if you're in that 17% who've done something. I imagine if you're in the 83% of the initial poll that haven't taken steps, I'm sure you probably thought about this issue. And go through this, fill this out, and share it with your financial advisor, your CPA, your attorney, and get moving on this process, because something could happen to you or your business partner tomorrow, and without the plan in place, you're setting your business up for a very, very rocky road.
Mark, what I want to do before we start taking some questions, and we have a bunch that came in, we want to take another quick poll. So the question is, and it'll show up on your screen in a second, after participating in this webinar, are you more or less likely to take steps to implement a formal succession plan? And again, that screen should be popping up in about, there we go. More likely, less likely, or the same. And if you can vote real quick, we want to get those results in so we can, 40% have voted. Modern technology. And then, Mark, I'm going to just quickly share the results with you in about 10 seconds. In the meantime, on your end, you can probably jump to the next slide.
Okay, I just have
we'll flip that back to you in a second. All right, and now I think we're ready for the results. And Mark, again, I don't think you can see the results. So 82%. Mark, I think this mission is accomplished. 82% of the people, of the business owners on this webinar, said that they are more likely to take the steps to implement a formal succession plan. That's great news. And 18%, about the same likelihood, which means 0 said they're less likely.
Wow. Well, I'm very happy to hear that, and everybody who participated in that poll, congratulations to you for realizing the importance of this.
And now I'm going to flip the slides back to you, Mark.
Okay. Well, I'm just going to do a very quick summary so we have some time to get to your questions. We addressed the issues that you see on the screen, and I'm not going to rehash everything. I'll move on to the Q&A and let Robert take it over.
Terrific. So we got a bunch of questions, Mark. I'm going to go into these as quickly as I can. Let's figure taking maybe about a minute or so to answer these. One question, a woman named Lori said, my husband and I have an S-Corp and he owns 100%. I'm technically an employee. We wonder what would happen if he died and how I would take control of the company or sell it.
Okay, so he would, I would assume, I would want to take a look at what you've got in your will, and I would assume he's leaving all his assets to you in his will, and you're going to take over ownership of the business. Now, if without somebody in the picture to buy that business from you, you're essentially stuck with it. And so I would suggest looking at, is there, if you're not in a position to want to continue running the business, and I think your question was how you're going to sell it, is you're going to hope that you can find someone that's willing to give you your fair market value for the business, which is unlikely. So I would suggest that you look within the company or outside of it to determine if there is anybody in the picture that could buy out the business. And
now, the interesting, you said the will. Now, probate, that whole process could take a while. Is there something else that they should be doing? Let's assume that she wanted to take control of the company. Or is it just enough to do it in the will, or is there something else she should be doing?
Oh, it's enough to do it in the will. I mean, you can also look into a living trust that would remove the probate process, and you could take over immediately. Or 50% of it could be transferred to her during her lifetime, if that's to give her some degree of control even prior to death. But this can be accomplished between a husband and wife within a will, absolutely.
Great. We got a couple of questions similar to this. I'm going to use one of these. Somebody said that they have a company that does, they said, north of $10 million in revenue, and they are the sole owner of the company. Mm-hmm. Everything you mentioned about cross-purchase and redemptions, how does all of this work when there's one owner?
Okay. The two types of agreements that we talked about, the stock redemption and the cross-purchase, assumed that there were two owners. If you have a business with one owner and you can find, whether it's a child or a key person, to buy out your interest in the business, you can structure your buyout agreement similar to the cross-purchase plan. So if I work for Robert, but I'm not an owner, and I want to buy him out, I would buy some insurance on his life, and I would have a legal agreement in place that said that in the event that he died or became disabled, I would buy him out. He wouldn't need to have the insurance on my life for that purpose, so it would be what we call it as a one-way buyout. And that would be your type of buy-sell agreement for the 100% owned business being sold to a key person or a child or a competitor.
Terrific. Next question. How often should you update your succession plan?
There's no set answer to that, but most good agreements I see in terms of the value of the business, that's updated on a regular basis, every year or 18 months. So the terms of the agreement, if the parties to the agreement don't change, they should be good for a number of years. You want to revisit it on a couple of years to make sure that nothing has changed within the business. But in terms of a formal update, if you have properly drafted valuation update provisions, you're going to be looking at the agreement every year, every 18 months to update the value to make sure that when you implemented it, your business was worth $1 million, and when you die, it's worth $10 million. To make sure that you're not in that position, to make sure that if you need to update your funding because the value has increased, you have the wherewithal to do that because you're taking these steps to actually look at the value on a regular basis. Of course, any time that the parties to the agreement change, you're going to want to look at the agreement. For example, you add a new business partner, and a child enters the business, you have a death, and so on.
So that leads to a similar, somewhat related question. Now, of course, valuations are not, they may not be that inexpensive for some business owners. If you're going through this process, when is a good time, or you're starting to go through this process, when is a good time to get a valuation? Maybe your exit is, you're planning your exit for 10 years down the road. When should you be thinking about getting a valuation?
Get a valuation now. Now, that's my opinion. That's, I think, shared by many in my field. Does that mean that you can't implement a good buy-sell agreement funded with the proper investment without a formal valuation? No, it doesn't mean that, but it's just less likely that you're going to be correct. So any time in the process that you get a formal valuation is good. Preferably now, so that you know, if I want to sell in 10 years, I still need to know today what the business is worth, don't I? I mean, so I can fund for the agreement. Often what we have in agreements is a drafted and legally binding recipe for chaos, which is at the time that somebody dies or becomes disabled, that's when you go out and hire the CPA or the professional valuation firm to do the valuations, and then the valuation for the seller is compared to the valuation that was required separately from the buyer, and if they disagree, then they go out and hire a third valuation firm. So it can get very expensive if your agreement is like most of them, where you wait until the last minute to get it done, and that also delays the actual transfer of the funds, creates a lot of confusion. So I would suggest now, if you just aren't going to pay a valuation firm, then move to the next step. You've got a value in your mind, what it is, then get a legal agreement in place and get the funding in place for that value that you believe the business is worth.
Terrific. Thanks, Mark. I'm going to ask you to flip over to the next slide. And Mark, I'd like to thank you so much for sharing your insights with us today. And, of course, I'd like to thank everybody that attended the webinar. This was absolutely fantastic. Personally learned a lot myself. I'd also like to thank Guardian for sponsoring this webinar. We have some great resources from Guardian available for you to download right now if you'd like to. And if you look in your chat box, you'll actually see the link right there. You'll find 2 documents that Mark showed us during his presentation, the buy-sell agreement checklist, and the last will and testament of a closely held business owner who didn't plan properly. In worst case, that provides for a good chuckle. Plus, you're going to also see some more information from Guardian on business continuation planning. And then, Mark, if you can head over to the next slide. We did try to cover a lot during this webinar. If you missed something or would like to share this with others, this webinar has been recorded and for your convenience will be archived at nyreport.com/webinar within 48 hours. You'll also be able to view the presentation slides at that location as well. And we will send you out not only an email right after within about an hour of the webinar, but we'll also send out an email to you when the presentation is up available on our site. So I'd like to thank everybody. Mark, thank you once again. I'd like to thank everybody for taking time out of their day, and this will conclude the webinar.